Imagine waking up tomorrow to find that the world's most powerful artificial intelligence company has just been, well, legally decapitated.
Oh, yeah, completely.
Right. Like its core code seized, its multi-billion-dollar profit structures wiped out entirely, and not at the end of some, decade-long Supreme Court battle.
Yeah, or like years of those grinding congressional hearings.
Exactly. Not that, but literally before lunchtime, via a single order from a federal judge.
It sounds like a tech dystopian thriller, honestly. But structurally, it is a very real, very immediate legal vulnerability.
Which is wild to think about.
It is. I mean, the prevailing assumption across Silicon Valley right now is that the Musk versus OpenAI lawsuit is going to follow the standard corporate litigation playbook.
The usual slog.
Right. You file a motion, the other side files a motion to dismiss, years pass in discovery, you have endless appeals, and then maybe in 2030 somebody pays a fine.
That is the predictable machinery of commercial law. Broken contract, here's the financial penalty, business continues as usual.
Exactly. Just a cost of doing business.
But the moment you step out of that standard commercial breach of contract stuff and you step into the realm of charitable trusts and fiduciary duties, that machinery breaks down entirely.
It shatters.
Yeah, it really does. And welcome to today's deep dive, because we are targeting a specific, highly detailed legal analysis of the pre-appeal remedies available in this exact lawsuit.
Which is a fascinating document.
It is. And our mission today for you listening is to map out how Judge Yvonne Gonzalez Rogers could deploy a legal mechanism that doesn't just penalize the company, but forcefully unbakes its entire corporate structure immediately.
The defining concept here, and this is crucial, is equitable authority.
Right. Break that down for us.
So when a court deals with a charitable trust, it is not merely acting as a referee measuring damages between two private parties. Like, it's not a standard fall.
Not at all.
No. The court acts as the ultimate guardian of the charity's original mission. So if the core asset in this case, artificial general intelligence research, was legally mandated to benefit humanity, the standard rules of commercial engagement are completely suspended.
They just don't apply.
Right. A judge wielding equitable authority can mandate or prohibit specific actions to achieve fairness, especially when simply paying monetary damages is, insufficient.
I want to pause right there before we get into the mechanics of that unwinding, because we have to address the meta source of this analysis.
Oh, this is the best part.
It is. The blueprint we are examining today, the specific roadmap of how to dismantle this commercial structure. Wait, I mean, the roadmap we're looking at, it wasn't authored by a team of antitrust lawyers at a white shoe firm.
No.
It was generated by an AI itself.
Mm-hmm.
Specifically, GPT 5.5.
But the irony is so thick you could cut it with a knife.
Seriously.
I mean, a prompter fed the core legal filings of the Musk lawsuit into the model and just asked it to analyze the pre-appeal remedies if the plaintiff prevailed.
And it just did it.
It did. The system coldly and methodically parsed the legal precedents of Delaware corporate law, California trust law, and equitable remedies, and synthesized a flawless playbook for its own structural dismantling.
Let's debate the validity of that for a second. Is an AI just, hallucinating legal theory here?
That's the first question everyone asks.
Right. Like, is it simply predicting the next most plausible legal-sounding token, or is it parsing actual binding case law? Because when you read this text, it is mapping out remedies that feel almost terrifyingly precise.
It is precise, extremely precise.
Yeah, it isn't just saying, oh, the company gets shut down. It is outlining the exact legal levers a judge pulls to strip the commercial entities of their assets.
Because it's demonstrating a highly sophisticated understanding of equitable remedies. The AI is not hallucinating the law here.
It's just applying it.
Exactly. It is applying the strict, unforgiving logic of charitable trust doctrine to a complex, modern corporate shell game.
Unforgiving is the right word.
It really is. It recognizes that if the foundational premise holds that the commercialization violated the nonprofit charter, then the subsequent corporate maneuvers are just legally void. It is objective analysis stripped of any instinct for corporate self-preservation.
To give you listening a sense of the scale of this, think of it like forking an open source software repository.
That's a great way to look at it.
Right. If you violate the core license of a massively popular open source project and try to take it proprietary, the original maintainers don't just fine you.
No, they lock you out.
Exactly. They legally lock you out, invalidate your proprietary branch, and legally revert control of the code base back to the public domain. The code keeps running, but the entity holding the ultimate administrative privileges changes instantaneously.
That is a much more accurate framework than a sports penalty, because the text explicitly focuses on the power of structural reversal. We are looking at a very hard line between preventative actions and reversal action.
Preventative versus reversal.
Right, preventative is hitting the brakes. The court issues an injunction saying, stop transferring assets, freeze the current corporate structure. It preserves the status quo.
Like hitting pause.
Exactly. Reversal, on the other hand, is putting the car in reverse and forcefully driving back up the cliff.
Wow. Okay, so the first reversal action the AI outlines is in order to immediately halt the continued transition toward a conventional for-profit structure.
Which is a huge deal.
Yeah, we know the company has been navigating this highly publicized, incredibly complex metamorphosis to shed its purely nonprofit origins and become, an investable standard corporate entity.
The mechanics of halting that are absolute chaos.
I can't even imagine.
I mean, you have hundreds of lawyers, tax specialists, venture capital firms, all restructuring cap tables, assigning intellectual property rights, and structuring profit participation units for employees.
All moving at once.
Exactly. And then a single equitable order drops and legally paralyzes that transition mid-stride. The filings stop, the equity distributions are frozen, the metamorphosis is just aborted.
But halting is just step one. The text then moves to an order restoring the nonprofit parent's full controlling authority over all commercial entities.
This is where it gets really aggressive.
It mandates the rescission of prior transfers. The exact phrasing is the rescission of assets, AGI-related intellectual property, licensing rights, and governance authority, taking all of that from the for-profit subsidiaries back to the nonprofit.
And this is where we hit the most profound technical and legal friction.
Because of that word, rescission.
Right. Rescission essentially means the court declares the original transfer of those assets to the commercial arm to be legally void ab initio.
Invalid from the start.
Exactly. As if it never legally happened.
Okay, I have to challenge the physical reality of that. How do you actually rescind AGI-related intellectual property that is already out there, integrated into the global software ecosystem?
That's the million-dollar question.
Right. It feels like trying to unbake a cake. We were talking about API endpoints handling billions of requests a day. Model weights physically sitting on server clusters owned by commercial partners. You cannot just hit Command-Z on the deployment of a foundational model.
Well, you're confusing the physical deployment of the technology with the legal title to the technology.
Yeah.
The court does not need to send U.S. Marshals to unplug the server racks. Rescinding the transfer is about instantaneously changing the name on the deed.
So the servers stay on.
Yes. Legally, the for-profit subsidiary wakes up one morning and discovers that the intellectual property it thought it owned, the neural network weights, the licensing rights, the training data pipelines, all of that now legally belongs entirely to the nonprofit parent board.
But realistically, if I am a tech giant relying on that API, the model still functions today.
Right, it doesn't break your app.
The difference is the entity I am legally paying, or the entity that holds the ultimate kill switch on whether I get to use it tomorrow, has fundamentally changed. The controlling board suddenly has a fiduciary duty to humanity, not a duty to maximize the API revenue.
Precisely. The underlying research infrastructure remains physically intact, but the control of those assets is yanked out of the hands of commercially incentivized executives and placed squarely under the control of a board whose sole mandate is a charitable mission.
So you don't delete the code, you rewrite the ultimate administrative privileges.
That's exactly it.
Which triggers an immediate financial earthquake. Because you cannot cleanly sever the legal title of the intellectual property from the billions of dollars surrounding it.
They're completely entangled.
Right. The IP doesn't exist in a vacuum. It is tied to massive revenue streams and compute contracts.
And the AI's outline directly targets this. It specifically cites subordinated agreements.
Okay, tell me more about that.
Well, the text notes the potential for an order voiding or restructuring portions of agreements that improperly subordinated the nonprofit mission to investor or commercial interests. And it explicitly names the arrangements involving Microsoft.
Wow. See, I am extremely skeptical that a single federal judge is going to risk breaking the global tech economy by voiding a multi-billion-dollar contract with Microsoft overnight.
It sounds impossible, right?
It does. Microsoft provides the physical compute, the massive liquid-cooled GPU clusters required to train these models. They didn't just write a check. Their infrastructure is fundamentally entangled with the creation of the asset. Wouldn't an appellate court issue an emergency stay within hours to prevent a market panic?
An appellate court might intervene, sure, but the bar for staying an equitable remedy in a charitable trust case is remarkably high.
Really?
Yes, because if Judge Gonzalez Rogers generates a factual finding that the original agreement with Microsoft inherently violated the nonprofit's founding charter by prioritizing commercial exclusivity over public benefit, well, the court has broad authority to sever the unlawful terms.
So what does that actually look like?
The court might not order Microsoft to pack up its servers, but it could void the exclusivity clauses, strip the profit-sharing mechanisms, or legally subordinate Microsoft's commercial rights to the oversight of the nonprofit board.
That is wild. It is the equivalent of a judge ruling that the seller of a skyscraper
Yeah.
never actually had the legal authority to sell it to you because it belonged to a public trust.
It's exactly.
You do not get to keep the deed just because you paid top dollar and installed the elevator.
Yeah.
And that brings us to the most aggressive financial mechanism in the text: disgorgement and constructive trusts. Let's break down those legal terms for the listener. What is disgorgement?
Disgorgement is one of the most powerful tools in equity. It is the required return of profits or financial gains derived from conduct found inconsistent with the charitable mission.
So let's break down the mechanics of disgorgement when the asset is intangible. If the for-profit arm generated billions in revenue from enterprise licensing and the judge rules the commercialization violated the trust, how do they calculate what is disgorged?
It's extremely complex.
Do they separate the profit derived from the model itself from the profit derived from the proprietary enterprise software wrapped around it?
That is exactly the kind of complex forensic accounting a court would mandate. Because disgorgement is not a punitive fine, right? It is the equitable removal of ill-gotten gains.
You literally have to get the money back.
Exactly. The legal philosophy is that you are not allowed to keep a single cent of profit generated from a breach of fiduciary duty. If the underlying model was unlawfully transferred out of the nonprofit, then the revenue derived from licensing that model is tainted.
All of it.
All of it. The court would order an accounting of all profits directly attributable to the core AGI assets.
But the company doesn't just burn that cash. Where does $1 billion in disgorged enterprise revenue actually go?
It goes into a constructive trust.
Okay, what is a constructive trust?
A constructive trust is a legal fiction. The court declares, we know your commercial entity technically holds this bank account, but because the funds were acquired through a breach of a charitable duty, we are legally treating you as a mere custodian.
Just holding it for the real owner.
Right. You are holding these assets in trust for the rightful owner.
Think of it like a bank robber. The bank robber didn't just get caught, but the court seizes the mansion they bought with the stolen money and turns it into a public library.
That's a perfect analogy. The rightful owner is the charitable mission.
So the court sweeps the disputed assets, the commercial revenues, and potentially even the equity interests held by executives into this court-supervised box.
Yes.
The funds are legally locked and can only be distributed for the benefit of humanity rather than as dividends to investors or stock buybacks.
It is the structural obliteration of the profit incentive. I mean, you cannot use a tax-exempt charitable mission as an incubator to build a mega corporation and then walk away with the enterprise value if the foundational rules expressly forbade it.
Which brings us to the human
The
element.
most unpredictable part.
Always. Because as much as we debate corporate veils and constructive trusts, humans are the ones making the decisions to commercialize. They are signing the Microsoft contracts. They are structuring the transition. And the text generated by the AI is incredibly direct about the fate of those humans.
Very direct. It explicitly outlines the potential removal or suspension of executives or directors found to have participated in breaches of fiduciary or charitable duties.
And it names names.
It does. It specifically names Sam Altman and Greg Brockman.
This is where I struggle with the practical execution of these remedies. You remove the CEO and president of a company whose entire valuation is built around their specific gravity in the tech ecosystem.
They are the face of the company.
Right. They're the chief fundraisers, the visionaries, the primary talent recruiters. If a judge removes them, doesn't that immediately destroy the value of the very asset the court is trying to protect?
But you are applying a commercial logic to an equitable problem.
Okay, how so?
Delaware corporate law heavily weighs the destruction of shareholder value. Charitable trust law does not.
It doesn't care.
Not at all. If the court finds that the executives violated their duty to the public mission, the preservation of commercial value is irrelevant. The court's priority is sanitizing the governance structure.
But who runs the ship? If you gut the board of anyone with a commercial conflict of interest and you remove the defining executives who's making the call on a Tuesday morning about whether a new model iteration is safe to train.
Someone has to allocate the server resources.
Exactly. Who's doing that?
Well, the AI's outline introduces a deeply invasive solution for that. The appointment of an independent compliance monitor with sweeping authority over governance, partnerships, safety, and AGI deployment decisions.
I want to dig into the friction here. How does a court-appointed monitor, who is likely a former federal judge or a massive law firm partner, actually evaluate a neural network for alignment issues?
It's a huge culture clash.
Yeah. You have a team of the smartest machine learning engineers in the world, accustomed to moving fast, and suddenly they have to explain their TensorFlow charts and safety evaluations to a legal monitor.
It is, but it's not unprecedented in tech antitrust. Look at the Microsoft antitrust case in the early 2000s. Special masters and technical committees were appointed to oversee compliance.
So they've done this before.
Exactly. The compliance monitor wouldn't be coding the models, but they would hold absolute veto power. The engineers would have to prove, to a legal standard, that a deployment does not violate the charitable safety mandate. Right. The monitor answers only to the court, not to investors. It completely inverts the standard corporate incentives.
It effectively puts the entire deployment of AGI into legal receivership.
Yes.
The court assumes the driver's seat because the current operators proved they couldn't balance commercial pressure with safety, which segues directly into the tests analysis of the technology itself, specifically the safety protocols.
This is where it gets really interesting regarding the future of AGI. The outline points to an order restoring or strengthening safety-based override powers.
The red button.
Yes, and it notes an allegation that former board members believed these powers had actually eroded over time.
That concept of erosion is fascinating.
It really is.
It implies that originally the nonprofit board possessed a functional red button, a mechanism where if the alignment team flagged a model as too dangerous, the board could simply halt the release, regardless of the financial implication.
They had ultimate say.
Right. But as billions of dollars in compute investments flowed in, the wire connecting that red button frayed. The momentum of the commercial enterprise became too massive for a nonprofit board to realistically stop.
And the judge's remedy is to legally rewire that red button, insulate it in titanium, and make it absolute.
No exception.
None. But the text goes beyond just safety overrides. It discusses an order preventing future commercialization decisions unless approved by a nonprofit-controlled board operating under fiduciary obligations to humanity rather than investors.
This phrase, fiduciary obligations to humanity, we have to do a massive deep dive on that alone.
It's the crux of the whole thing.
Because it is the philosophical core of this legal dispute.
Right.
We are so fundamentally conditioned by standard corporate law, specifically the duty to shareholders. If you run a company, your absolute legal mandate is to maximize financial return.
Right.
If you leave money on the table, you face derivative lawsuits from your investors.
It is a well-established, highly quantifiable metric. But a fiduciary obligation to humanity is a radically different paradigm.
It sounds so abstract.
It is abstract, but in a courtroom, it has massive practical teeth. It mandates that global welfare must be prioritized over any commercial gain.
Let's apply that to a concrete hypothetical. Let's say the company develops a new model that will generate $50 billion in annual enterprise licensing.
A massive windfall.
Huge. However, the internal red teaming reveals a 5% chance the model could be jailbroken to synthesize novel biological pathogens. Under a standard Delaware corporate structure, a highly risk-tolerant board might look at that, implement some software guardrails, and authorize the release.
Because the fiduciary duty to capture that $50 billion market share is overwhelming.
Exactly.
And if they delay the release, the investors will literally sue them for mismanagement.
Right. But under a legally enforced fiduciary obligation to humanity, that $50 billion upside is assigned a legal weight of 0. The financial gain cannot even be placed on the scale. The only calculus the board is legally permitted to make is the welfare of the public. A 5% risk of biological catastrophe overwhelmingly vetoes any deployment. The judge is essentially forcing the company to operate under a mandate where profit is legally irrelevant to strategic decision-making.
It fundamentally rewrites the DNA of tech governance. But, there's a massive tactical problem here.
Oh, absolutely.
Because all of these remedies, voiding contracts, disgorging profits, changing the board, rewriting the fiduciary mandate, these take months, if not years, to properly execute, even with an immediate order.
So how does the court stop them from just running away with the tech?
Right. How do you ensure the company doesn't just quietly transfer the model weights to an offshore server or sign a new irrevocable licensing deal while the paperwork is being finalized.
You deploy the tourniquet, the lockdown phase. The text outlines a series of immediate injunctions and preservation orders to freeze the current state of affairs.
Exactly. The outline details injunctions blocking any additional transfers of IP, compute infrastructure, equity, or strategic control into commercial entities during the litigation or the appeal process.
It is the legal equivalent of throwing yellow caution tape around the entire server farm.
Mm.
Nobody touches anything.
Right. If the underlying fear driving the lawsuit is that the nonprofit assets are being unlawfully siphoned into a commercial vehicle, the injunction freezes the architecture in place. Not a single hard drive, not a single line of code, not a single share of equity can move from column A to column B.
And the preservation orders cover internal communications, AGI evaluations, investor negotiations, and restructuring discussions. Let's talk about the reality of modern tech communication for a second.
It's completely informal.
Exactly. Companies run on Slack, Signal, ephemeral messaging. A preservation order means every single deleted draft, every casual Slack message questioning a safety protocol, every internal memo from the last 3 years is now frozen and subject to discovery.
Which paralyzes the fluid, informal communication tech culture relies on. Every email is now evidence.
It has to be terrifying for them.
Oh, it is. But the truly dangerous aspect of this preservation order, as the text notes, isn't just for the immediate trial. It explicitly mentions the data is preserved for, quote, possible future proceedings or regulatory review.
Which opens up an entirely new, terrifying flank for the company. The text introduces the concept of referral findings.
Yes.
It states the court's factual conclusions could trigger separate actions or investigations by state charity regulators, and it explicitly targets the California Attorney General.
This is the legal cascade. Judge Gonzalez is presiding over a civil dispute between Elon Musk and OpenAI. But if she proceeds through this analysis, issues the injunctions, reviews the preserved internal communications, and ultimately concludes that the charitable trust was violated, well, she is doing the heavy lifting for the state government.
She is generating a gold-plated, court-tested factual record.
Yes. She is essentially handing a prepackaged prosecution to the California Attorney General.
And the AG has sweeping, draconian powers over any nonprofit operating within the state. If a federal judge has already formally ruled that the corporate maneuvers violated the charitable mandate, the AG can simply take that ruling and initiate a massive state-level dismantling of the commercial apparatus.
The AI's outline refers to a declaratory judgment, formally stating that OpenAI's founding nonprofit commitments legally constrained later commercialization efforts.
A declaratory judgment.
Right. It is the court formally establishing the objective reality of the law. Once that judgment is entered, it binds the future. It states definitively, you promised the public you were a charity, and that promise permanently encumbers every piece of technology you build forever.
Wow. Stepping back, the scale of what we've mapped out today completely shatters the narrative that this lawsuit is a slow, grinding corporate skirmish.
It's not a skirmish, it's an existential threat.
The text, generated by the very AI at the center of the dispute, reveals a blueprint for immediate, catastrophic structural reversal. We are looking at a scenario where a single judge can order the intellectual property yanked back under nonprofit control.
The potential voiding of multi-billion-dollar compute and licensing contracts with Microsoft.
Yep.
The equitable disgorgement of massive commercial revenues into a court-supervised constructive trust.
The forced removal of foundational executives, the gutting of the commercial board, and the installation of a legal compliance monitor holding absolute veto power over the deployment of artificial general intelligence.
Basically, the strongest version of this ruling effectively declares that the company never possessed the lawful authority to permanently place humanity-oriented nonprofit assets under dominant commercial control.
And for you listening, why does the mechanical breakdown of one company's corporate structure matter? Because it proves that the very DNA of who controls our future technology, who decides when AGI is deployed, who determines the safety thresholds, who captures the economic value, is not exclusively held by venture capitalists and tech founders in closed boardrooms.
They don't have the final say.
No, they don't. The legal system, wielding equitable authority, still possesses the teeth to violently pull the leash on the most advanced technology in human history.
It is a profound check on the assumption of inevitable corporate dominance in the AI space, but it leaves us with an incredible paradox to consider.
I know you have a final thought on this. What is the thread to pull on here based on this text?
Well, if a federal court establishes that a fiduciary obligation to humanity legally supersedes standard investor rights and effectively blocks the profit maximization of AGI, does this ruling effectively make artificial general intelligence legally too powerful to ever be owned by a standard profit-driven corporation ever again? And if so, how does any future AI developer raise the hundreds of billions of dollars in capital required to build it in the first place?